you've got this Presidential Records Act that gives the president discretion to keep records as personal. And there's no restriction on that. And that was the prior position of the Justice Department and the prior position of the archives. The other big news this week, I thought, was some material that was filed in the court in Miami where President Trump is set to be tried. Now, the government, the Biden regime, wants to get Trump prosecuted and jailed as quickly as they can before the election, and Trump, for obvious reasons, is opposing that. And there's a tweet I wanted to read from President Trump. I forgot to print out, or it's actually from me, highlighting something in his brief. Hold on a second, let me see if I can find it here. While my computer here or my phone is warming up, what happens is the government wants to set a trial date. The Trump legal team wants to delay the trial, so now there's back and forth before the judge down there. Let me see. Trump legal team. This is what I wanted to read. So this is the tweet I put out there. I got a few tweets quoting in the brief. And this is the nice thing about Twitter recently, is they've allowed longer tweets that I can quote more fully from Judicial Watch press releases, interesting court decisions, and other primary documents, so that people can look at the material directly on the platform as opposed to moving, having to go somewhere else and figuring out where it is. New court filing from Trump legal team details massive constitutional battle against Biden regime's scheme to jail Trump before the election. So that's the headline I put on Twitter in introducing this Trump filing, and that's why the left hates me, because I understand what's at issue and describe it accurately and consistently and dramatically. This extraordinary case, and this is what the Trump team filed. I think it was, when did they file it? This is filed on July 11th, so I think it was filed either late Friday or late Monday. This extraordinary case presents a serious challenge to both the fact and perception of our American democracy. The court now presides over a prosecution advanced by the administration of a sitting president against his chief political rival, himself a leading candidate for the presidency of the United States. Therefore, a measured consideration and timeline that allows for a careful and complete review of the procedures that led to this indictment and the unprecedented legal issues presented herein best serves the interests of the defendants and the public. The intersection between the Presidential Records Act and the various criminal statutes at issue have never been addressed by any court, and in the defendant's view will result in a dismissal of the indictment. The authority vel non, V-E-L-N-O-N, vel non I think is Latin, well I know it's Latin, I think it's Latin for the opposite of, so the authority or lack thereof, right? Of the special counsel to maintain this action likewise presents a potentially dispositive issue of first impression in this court. Additional significant matters include the classification status of the documents and their purported impact on national security interests, the propriety of utilizing any, quote, secret, unquote, evidence in a case of this nature, and the potential inability to select an impartial jury during a national, impartial jury during a national presidential election. Moreover, the extensive and voluminous discovery, coupled with the challenges presented by the purportedly classified material that is yet to be produced, will require significant time to review and assimilation. Proceeding to trial during the pendency of a presidential election cycle wherein opposing candidates are effectively, if not literally, directly adverse to one another in this action, will create extraordinary challenges in the jury selection process and limit the defendant's ability to secure a fair and impartial adjudication. Here, there is simply no question any trial of this action during the pendency of a presidential election will impact both the outcome of that election and, importantly, the ability of the defendants to obtain a fair trial. The government's request to begin a trial of this magnitude within 6 months of indictment is unreasonable, telling, and would result in a miscarriage of justice. So there you have it. And one of the things he mentions there, Trump's team mentions there, is the Presidential Records Act, 2 issues, and the constitutionality, or suggests that the special counsel is constitutionally infirm. Now, I will go over again. You've heard me say it before, and I'm going to say it again because it's key, in my view, to the corruption targeting Trump. The Presidential Records Act has traditionally understood by the Justice Department, the National Archives, and most famously, all of which they, most famously in the Clinton sock drawer case, where he kept what we believe to be and what in theory were presidential records in his sock drawer, they deferred to the president as to what records were personal and which records were presidential. And that necessarily meant which records were classified, which ones he declassified under his power as president. Similarly, that would apply in theory to the Espionage Act, which has additional restrictions on defense information generally. Now, if the president on his own power can declassify material, why couldn't he similarly make available under his authority as president to himself these records that allegedly are covered by the Espionage Act? Of course he can. And so that's what the president is saying there, that they've got this Presidential Records Act that gives the president discretion to keep records as personal. And there's no restriction on that. And that was the prior position of the Justice Department and the prior position of the archives. And it was the decision of a key case that Judicial Watch had pursued, which we lost, seeking the Clinton sock drawer tapes. So when he references the Presidential Records Act, that's what I think he's referencing. But he also talks about the constitutionality of the special counsel. And this is where, I guess someone on Twitter said, what does he mean there? And I don't know exactly what they meant, but I do recall being upset with the idea of having an outsider get hired to prosecute and run grand juries without being confirmed by the Senate, as every U.S. attorney is. And so what happens is you've had, in this case, Jack Smith, who no longer works for the Justice Department, get hired essentially as a contract employee under the special counsel regulations, and he gets to run a prosecution and try to jail someone without day-to-day supervision by someone who has the authority to do so, U.S. attorneys or confirmed officials in the Justice Department, such as the Attorney General. So you can't have your cake and eat it too. You can't say that Jack Smith has full authority to do anything he wants without saying what the basis for that authority is. And that has to be someone who's confirmed, as the Constitution requires, when the exercise of that authority by the U.S. Senate. And if Garland is running this, or an appointee of or someone who's also confirmed is running this, then what's the purpose of a special counsel? Now, I guess in theory you could have a U.S. attorney made special counsel, and you wouldn't run into that constitutional issue because a U.S. attorney is confirmed by the Senate. So that's the question there. That was the question for Mueller as well. And I don't think the D.C. courts bit. I don't think anyone raised it. I think maybe one of the witnesses or targets raised it, but they didn't get anywhere with the D.C. courts. But there's a new court in Miami, and they may look at this afresh. So that's the constitutional issue. Does Jack Smith have the constitutional authority to run grand juries, issue subpoenas, and prosecute U.S. citizens under our constitutional system? I think it's an open question, and I'm skeptical that that's the case. I said that for Mueller, and I don't see why Jack Smith is any different. Also in Trump's court filings, he also highlighted some interesting issues about the evidence that was given to him. Trump's legal team, as I introduced this clip or this section from the filing he made, Trump's legal team highlights how Biden regime playing games on evidence in its efforts to jail Trump before the election. The government anticipates, and this is a quote from the Trump legal team's brief on behalf of President Trump, the government anticipates producing discovery in stages due to the sheer volume of documents collected and because of procedural mechanisms necessary to protect against the unlawful production of classified information. The government produced its first production of unclassified discovery on June 21, 2023. The initial production was substantial and voluminous. Therein, the government produced more than 428,300 records in excess of 833,450 pages, consisting of approximately 122,650 emails, including attachments, and 305,670,000 documents gathered from over 90 separate custodians. The initial production also identified some 57 terabytes of compressed raw CCTV data, closed-circuit television. So far, there is approximately 9 months of CCTV footage, but the final number is not yet certain. In addition, there will be additional productions of discovery provided by the government as it continues to process some devices and search warrant returns. Notably, the government has not produced all interview-related materials, including certain witness statements and associated memorialization of those statements. The government has not informed the defendants when it anticipates producing additional discovery, what that discovery entails, or to even approximate when it will be in a position to fully comply with its discovery obligations under the law. The government's efforts are ongoing, and the defendants have no insight into when this will be complete, nor do any of the parties know when the classified discovery will be made available to defendants. Thus, in addition to the extraordinary volume detailed above, there will be further discovery. So they've got a lot of documents, 1 million pages almost, and they're expecting to get more documents. And on top of that, there's this issue of classified information and who gets to see them, how and when, and whether the jury ultimately will be able to determine this information is being faithfully and accurately and truthfully described as either national defense information, the release of which without authority would damage the United States, or classified information. Trump's legal team highlighted how the Biden regime, again, wants to jail Trump based on secret evidence, as I was implying here. And they told Judge Cannon, who is the judge in this case in Miami, there should simply be no, quote, secret, unquote, evidence, nor any facts concealed from public view relative to the prosecution of a leading presidential candidate by his political opponent. Our democracy demands no less than full transparency. So I read all that stuff from Trump's brief because you're never going to hear it from the media, folks. You're never going to hear the strong legal defenses that Trump has against this wild abuse of power by Biden from the media. And indeed, the Biden Justice Department filed a brief in opposition, and their response to Trump was, oh, too bad. Getting a jury is always going to be tough. We'll get a jury, don't worry. By the way, we gave you 800,000 pages of records, but we told you the important ones. So you should just believe us and look at only the important ones we told you to look at. Oh, we gave you 9 days of video footage. Oh, we told you the important footage. So you shouldn't look at any of the other material, even though we gave that to you because we were required legally to do so. So that's the Biden regime's response. And they said, oh, the Presidential Records Act? Well, maybe somewhere, some court might be interested in that, but we shouldn't hold up the entire case for a crackpot legal theory that is never going to go anywhere. And so the judge should just ignore the substantial issues that not only have I raised here, as I'm explaining, but the Trump legal team says they're going to raise. So it's the Biden regime acting as a regime. And they want the trial to take place just a few weeks before the Iowa caucuses. The Iowa caucuses, I think, are going to be early January at this point, January 13th or so. And the trial they want to begin on December 11th. So they want to try and potentially jail Trump 2 or 3 weeks before the Iowa caucuses begin. in the middle of the presidential primary. How is that not anything but election interference? How on earth could a federal judge allow that to take place? And I don't think this judge nor any other judge, frankly, fairly applying the law and being careful about the rights of President Trump would allow it to take place. But of course, Judge Aileen Cannon, who was a Trump appointee, because she has been skeptical in the past, previously, of Biden administration ethics, frankly, and the way they've handled this case to date, the left has been very angry with her and they've been targeting her. So Judge Cannon is going to be facing a lot of pressure to try to join the Biden regime's effort to improperly jail President Trump. And so let's hope that she resists that siren call of political conformity and is blessed with the wisdom and discretion and discernment to apply the law faithfully and protect President Trump from what I believe to be a widely abusive prosecution that should never get out the starting gate, meaning that she can't shut it down soon enough. So that's where we stand on the Trump case, and you know the American people deserve a full update on this because this is ongoing election interference by the Biden regime. Jack Smith works for Merrick Garland. Merrick Garland works for President Biden. President Biden has the final say whether this proceeds. It only proceeds with his permission and acquiescence. So in the end, this is a Biden prosecution of his #1 political opponent in the months before presidential election. And that normally happens in dictatorial regimes. And so if you're in China and Moscow, you probably understand this much more clearly than you would if you're just relying on the liberal media, who are happy to advance this effort by their political allies, the Biden regime, to jail Trump. And of course, you know, when you have the Justice Department focused on doing nothing but jailing Trump, it allows and gives them an excuse, and frankly makes it harder for them to prosecute Biden or anyone around Biden. So when you compare and contrast that, for instance, the special counsel looking into Joe Biden's supposed mishandling of classified information, his records case, which is frankly much more substantial legally, because he had records from his days as a Senate that were classified, so none of this Presidential Records Act exceptions apply to him. I mean, he's only spent a few $100,000. I think Jack Smith's budget that he held up and kept secret from us, even though it was due several months ago, he spent $5.5 million in the first 4 months of the year. So that shows you the priorities. If you want to know what the government priorities are generally, figure out what they're spending money on. And they're spending money on going after Trump and spending less money on Biden, suggesting that they're protecting him. So there you have it. And of course, Judicial Watch is continuing to push hard for all the information we can get from the Biden administration about this abuse of Trump, including who's working for Jack Smith. I mean, they're spending $5.5 million and they don't want to tell us who's working for him? In violation of federal law requiring disclosure of high-level officials involved in government investigations like this? You know why they don't want to tell us who's working for them? Because they're afraid that it's going to be a list of names that everyone is quickly going to see are Democrats or Democrat-connected or Democrat donors. Because let me just be clear here. Forget about the indictment of Trump. Just take that out of the equation. The Justice Department is largely populated by leftists and Democrats. Now, is there a Republican and a conservative there hired? Sure there are, in any government agency. But the Justice Department is like 90%, I'm exaggerating. But in terms of decision making, and I don't even mean this in a Democratic administration, I mean it's still in a Republican administration. Virtually all the civil servants, all the top lawyers are Democrats and leftists. And that means they support leftist causes, both political and cultural. I mean, let's put it this way. You're going to find, I guarantee you, you're not going to find any significant Republican donors in the list of lawyers who work for Jack Smith. They just don't exist in the Justice Department. They just don't. And if they do, they're the exception that proves the rule. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.